I am Harisree, an active human rights activist in All India Human Rights Association. Today, the topic which I am going to deal is probation. So, oftenly people have a misunderstanding regarding what is a probation and what is a parole, or usually people do not know the difference between the probation and parole. So, both are different terms. So, today I am going to deal in this video is the term probation or the concept probation. So, the term probation is derived from a Latin word probate, which means to test or to prove. So, according to H.S. Cunning, probation is a matter of discipline and treatment. So, it is a conditional release of an offender under supervision as a corrective measure. So, it is as a reformative measure, and it is for the people who is under the age of 21. So, as I earlier stated that it is like probation is a conditional release of an offender under supervision as a corrective measure. So, as yes, this supervision may be in two ways. First one is before custodial sentence, which is called the probation, and after the custodial sentence, it is called the parole. So, this is the difference between the probation and the parole. So, second one is the next one is the definition of probation. So the definition of probation says that according to section 4 of Probation of Offenders Act 1958, when any person is found guilty of having committed of an offense not punishable with death or life imprisonment, and the court by which the person is found guilty is of the opinion that having regard to the circumstance of the case, nature of the offense, character of the offender, then notwithstanding anything contained in any other law for the time being in force, the court may, instead of sentencing him at once to any punishment, direct that he be released on his entering upon with or without sureties of securities to appear and receive sentence when called upon during such period not exceeding 3 years, as court may direct, and the meantime to keep the peace and to be of good behavior. So this is the basic definition of probation in the Probation of Offenders Act 1958. So according to this definition, there are some essentials for constituting a probation. So the main essentials are the first one is the person commit offense where the punishment is not death or life imprisonment. So the second one, he was proved guilty. So the third one is court after keeping nature or after looking the nature, character, and circumstances of the circumstances of the crime, to opinion that to not go give sentence for a period. So next point is maximum 3 years in a condition for appear before the court, and last condition is he or she have to maintain peace and good behavior. So this is a reformative method of punishment. So this probation is granted to all person who possess good character, haven't committed any serious crime which is punishable with death or life imprisonment. Third one is this person can be expected to reform in the future. So the assessment is made in view of, or the assessment to give or not to give probation is in the view of the character of the offendant and the nature of the offense committed by him. So it we can say that it is a judicial kindness due to sympathy. So this, as I earlier stated, that this will give, or this method or this treatment method will give a uh, person an opportunity to reform. So the what is the object of the probation? So object of the probation is, first one is to provide chance of reformation. Second one is to save such category of person from stigma of jail life, that when a person become in jail, he will be always whether he is guilty or not, he will be an offender. That is a social stigma which is present in our society. So a main object of the probation is to save a person from the social stigma. And the third one is to save from contaminating influence of hardened prison inmates, which means when a person is in the prison, or a person is there's a theory like survival of the fittest. So when a person is living with offender, or who's in the prison, he may have his character may be influenced with the wrong behavior of the offenders, or his character may influence with the character of the inmate. So the person who who got probation will save from contaminating, so he will be saved from contaminating him from the influence of hardened prison inmates. So fourth one is to help reducing overcrowd in the jail. So it helps to reduce overcrowd in jail. So third one is the next one is the advantages of probation. As I earlier stated that he is saved from going to the jail. And next one is it reduce helps to reduce overcrowd in jail. So and also it is like probation is given for, or giving a chance for a person to reform. And next one is to create self respect and to create a fear from committing a crime again. And the last advantage is offenders are not separated from his family. So as there is an advantage, there will be an disadvantages also. So the main disadvantages are it creates discrimination, because this probation is given only to the person um, persons who committed crime which punishable up to not which is not punishable to life imprisonment or death. So they do not get the chance of probation. So that's create a discrimination. So next one is the complete power of, there is no like there is no legislative, or there is no act of, yes, there is an act of probation of offenders act, but whether whom to give, whether a person is eligible for probation or not is completely up to the judiciary. And next disadvantage is not all persons are reformed. So the last disadvantage is several persons are not stopping committing crime due to the fear of jail life. So next one is there are some case laws regarding the probation. First one is Devaki versus State of Haryana, 1979. So in this case, uh, a 17-year-old child was kidnapped and forced for rape. Accused told for the benefit of the probation, but the court held that there is no probation for sexual offences. So, in the case of state of Himachal Pradesh versus Dharampal, in this case also the Supreme Court held that there is no probation for the crime which is committed or which is punishable under section 376 of IPC, which is the punishment of rape. So the third case is Ram Singh versus State of Haryana, which is in 1971. So in this case, Supreme Court held that the report from a probationary officer is when a person is in probation. So after his probation period, a report from the probationary officer is mandatory. So this is the basic thing regarding the probation. Hope you all understand about the video, and thank you.